Assalamualaikum warahmatullahi wabarakatuh. We are from Group 3 and will present on the case review of the Bank of Nova Scotia Berhad and another against Lion DRI Sdn Berhad and others 2021. Our group members consist of Nabiha Anisa binti Ahmad, me myself Nurul Farhana binti Baharuddin, Syahidatul Husna binti Ibrahim, and Wan Nur Fatihah binti Wan Azhari. We will go to the first one, which is on the facts of the case. Next. The plaintiff in this case is the Bank of Nova Scotia Berhad and another, where the first defendant looked for the funds. As the first defendant's debenture holder, the plaintiffs filed the current originating summons against the defendants under Section 346 of the Companies Act 2016. It is claimed that the second and third defendants conducted activities that were unfairly prejudicial, discriminatory, damaging, or disregarding to the plaintiff's rights as debenture holders. The plaintiffs are seeking for the originating summons under such reliefs. A. By Prayer 1, the plaintiffs seek various declarations that the first defendant's affairs have been conducted, the powers of the directors have been exercised in a manner oppressive to or in disregard of the plaintiff's interests as debenture holders of the first defendant. That the defendants have procured and caused to be done acts that have unfairly discriminated against or were otherwise prejudicial to the plaintiffs as debenture holders of the first defendant. B. Through prayers 2 and 3, the plaintiffs seek an order holding all defendants jointly and severally liable to pay to the first plaintiff with interest. And C. Through prayers 4 and 5, the plaintiffs seek an order holding all defendants jointly and severally liable to pay the second plaintiff plus interest. As for the defendant, it is Lion DRI Sdn Berhad as the first defendant in this lawsuit. At times and in all circumstances, the second and third defendants were the directors of the first defendant. They also serve as directors of Mega Steel Sdn Berhad. The defendants have petitioned to strike the originating summons under Orders 18 and 19 of the Rules of Court 2012. The grounds observed are A. The plaintiffs lack locus standi because they are not debenture holders within the meaning of Section 346 of the Companies Act 2016. B. There are no ongoing acts of operation in existence at the time of filing the OS that are remediable by this court. C. The gist of the claims in the OS is a corporate complaint actionable by the first defendant and not by a debenture holder under Section 346 of the Companies Act 2016. In this case, the first defendant consented to manufacture and supply hot direct reduced iron to Megasteel to manufacture steel products known as hot rolled coils and cold rolled coils under an offtake agreement between Lion DRI Sdn Berhad and Megasteel Sdn Berhad. To carry out the offtake agreement, the first defendant required funds to purchase iron ore, which was the raw material used to make the product and finance the construction of its plant, which is the DRI plant. The DRI plant was to be built on Megasteel property, which also housed Megasteel's production facilities. The Lion DRI Sdn Berhad then held a long-term lease on a piece of Megasteel's land, where the DRI plant was built and placed. The first defendant sought funds from the plaintiffs so that the plaintiffs provided it with banking facilities, and in exchange, the plaintiffs received various security interests in the facilities. One of these securities was a debenture over the first defendant's assets and undertakings. The first plaintiff held the debenture as security agent for the facilities on behalf of the second plaintiff. The first plaintiff was the sole holder of the first defendant's debenture. The first defendant would use the plaintiff's facilities to purchase iron ore to manufacture the products at its DRI plant on the leased land. The first defendant would then sell the product to Megasteel, who would use the product to produce steel products and goods for its customers. On the other hand, Megasteel did not make the required payments to the first defendant for the product in full or on schedule. Megasteel's trade receivables to the first defendant had continuously increased, with impairment losses recorded beginning in the 2012 financial year. By the end of the 2016 financial year, the entire Megasteel trade receivables business had been impaired. The first defendant had terminated operations on or even before 31st January 2016. The first defendant made no more drawdowns from the facilities until it ended operations in early 2016. Therefore, in this case, the court found that the defendant's side was more persuasive, thus striking out the originating summons filed by the plaintiffs with cost. I will pass to the next presenter. Thank you.
So we move to the decision of the court. The court struck out the originating summons made by the plaintiff for the reason of the limitation on the interpretation of the debenture of the term debenture holder in Section 346 Companies Act 2016. The definitions of debentures and securities under the Companies Act 2016 and the Capital Markets and Services Act 2007 demonstrate that a debenture tends to mean debt or financial instruments issuance for raising funds. As regards to Section 346 Companies Act 2016, this section only applied if a minority was in the class oppressed by the majority of the class or if the director's powers were being used to oppress the minority of that class. Meanwhile, the second defendant was not considered to be a complainant under Section 346. By only knowing that the second plaintiff was the beneficiary of the debenture was inadequate to give rise to an estoppel on the ground that the interests of the first and second plaintiff are balanced. The plaintiff claim was nothing more than an incorrect attempt to recover their debt from the second and third defendants after the first defendant could no longer meet its contractual obligations to the plaintiff. The action under Section 346 Companies Act 2016 was not instituted when the claimant can stop the oppressive action and or the ability to self-help. In conclusion, as a result, the plaintiff originating summons could not be upheld. I pass to the next presenter.
Then we continue with the ratio decidendi slide. Firstly, to begin, the judge stated in his decision that in construing the meaning of the term debentures holder in Section 346, this court must adhere to the meaning expressed and specified in Section 2 of the Companies Act 2016. He agrees with learned counsel for the second and third defendants that a thorough examinations of the definitions of debentures and securities under the Companies Act 2016 and the CMSA clearly demonstrates that a debentures for the purpose of the Companies Act 2016, unless the context require otherwise, means that debt of financial instrument issue for arising from instrument or transaction affected in the money market. In fact, the whole subdivision 10 of Part 3, Division 1 of the Companies Act 2016, dealing with debentures, refer to debentures as debt instrument issued by a firm and made available for subscription to the public. Secondly, I hold that the plaintiffs are not debentures holders under Section 346 of the Companies Act 2016 and hence do not have legal standard to file an application under that provision. The court writes, the judge ruled that the plaintiff lacked legal standard to file a Section 346 application. I further hold that The first plaintiff lacks local standard to use Section 346 of the Companies Act 2016, since the first plaintiff is the sole holder of the first defendant's debentures. The court continues. Only when a minority within a class has been oppressed by the majority of that class, or when the director's power are being utilized in a way that oppresses the minority of that class, is Section 346 of the Companies Act 2016 relevant. Then the local standard of the second plaintiff. Next slide. In my view, I hold that the second plaintiff does not qualify as the complaint under Section 346. The court added. Courts have found that people who claim to have beneficial interest in a company's share through a registered member lack the required local standard to file an action under Section 346 using the clear language of Section 181 of the now repealed Companies Act 1965, the forerunner to the current Section 346. Accordingly, I conclude that the plaintiff's claim is nothing more than an illegal attempt to collect their loans from the second and third defendants, seeing that the first defendant is no longer able to satisfy its contractual commitments to the plaintiffs. It's an obvious violation of Companies Act 2016 under Section 346. There is no existing operation. The judge ruled that the plaintiff's claim is nothing more than an illegitimate attempt to collect their debts, and that this case comes under Companies Act Section 346. And I also agree with expert counsel for the first defendant that an action under Section 346 does not lie, concludes the judge. According to this, the judge agrees with key counsel that Section 346 does not apply where a claimant has the ability to halt allegedly oppressive activities and perform self-harm, as long as the claimant has the authority to halt oppressive or unfairly prejudiced conduct or to perform self-harm. There is no such thing as unfair bias. Then I will pass to the next presenter.
Now we move to legal opinion. Next. There has been no recorded judgment in which a debenture holder sought a portion relief under Section 346 of the Companies Act 2016. The decision also considers whether a class of debenture holders must exist before one or more of them can bring an opposition action. The case examines whether the term debenture holder refers limited to holders of tradable debt instruments and excludes holders of security delivered to bankers in exchange for commercial loans. Plaintiff laid local standby because they are not debenture holders under Section 346 of the Companies Act 2016. At the time of filing the OS, there were no ongoing act of operation capable of remedy by this court. The gist of the claims in the OS is a corporate complaint actionable by the first defendant and not by a debenture holder under Section 346. This opens the door for the company's creditors to bring operation proceedings in order to reclaim their debts. It would open the floodgates for banks or lenders who have obtained debentures as security to bring an action under Section 346 to recover the outstanding debts from the subject company shareholders and directors personally when faced with perceived difficulties. The plaintiff in the Megasteel case are not debenture holders under Provision 346 of the Companies Act 2016 and consequently lack local standards to file an application under that section. In Galantis, the fact that the rest of the purchase price remained unpaid did not imply that operation existed that could be addressed in court.
according to the court, implying that tyranny continues in perpetuity until the judgment debt is paid extends the definition of oppression too far. Lawyers for the first and second plaintiff jointly and severally filed an order of obscure settlement against the third defendant on May 10, 2019. The complaint centered on the first defendant's alleged violation of the provisions of the Facilities Agreement and ongoing dealing with Megasteel. It is impossible to assert in this case that there was a currently oppressed interest at the time these actions were initiated. As a result, Section 346 is inapplicable. Next. An action under Section 346 does not exist if a claimant has the ability to help the allegedly oppressive activities and exercise self-help. As such, it is presented to attain a secondary goal and constitutes a process abuse. For the foregoing reasons, the plaintiff's OS is dismissed with cause set at 10,000. So that's all from our group, and thank you.